letters of administration. So really, it is a document. It's usually one page. It's a letter-sized page, and it is what authorizes whoever is the holder, who is named there as a person, to take charge of the property of someone who died without a will. So letters of administration, or put it loosely and easily, is a one-page document authorizing a particular person to manage the property of someone who died without a will.
Right. Now, I have several directions to take this, but
No problem.
The first piece is that we understand that a letter of administration is an
letters.
Letter, sorry, thank you. Letters of administration is an instrument that comes from those who die intestate, or
it's better we say comes from the court.
From the court, right?
To cover those who died intestate.
Intestate, thank you. What governs that document? Is it, well, mommy say, and well, I clean her last, and what? So
it's the easy thing. What governs that is how close you are as a blood tie to the person who died. So you may be close to that, but it's a blood tie. You may be close to that person as the caregiver, like you rightly said, the last person who was at the bedside. Yes, you may be, but when it comes to letters of administration, we're dealing exclusively with blood ties and the nearest blood tie. And strange enough, your wife, Mr. 𝗪𝗁𝘁'𝘁, is a closer blood tie to you than your daughter.
Wow.
Yes.
That's
how serious marriage is. And because women don't like to hear that at all. Bone of my bone, she came from me, he came from me. How could a husband who I long got rid of, or who treated me so badly, how he could be closer to me than my children? Something wrong with that. But in law, as a matter of fact, I was just looking at the line all the way to Singapore. I was very surprised. The legislation is, how we like to say it in Trinidad, exact same.
Exactly.
It is the very same thing. So across the board, the husband and wife is like a sanctimonious, a tie that is unbreakable except for marriage. Divorce. Right. Okay. So when it comes to intestacy, it's all about bloodline and the closeness the proximity of you to the person who died.
Okay. So just give an example. John Doe has a wife, Mary Jane, and they have two children, Boyo and Carla. John Doe dies. What does letters of administration governed by the Succession Act say?
Right. So we have John Doe, Jane Doe, and they have two children. You could see you've been reading the Trinidad and Tobago primary school books, Boyo and Carla. Right. So John Doe is out of the picture. He's still married to Jane Doe. According to the law of succession you rightly quoted, Jane Doe is the nearest next of kin. So Jane Doe becomes the applicant once she's in her right frame of mind, she's not ill, etc. She's automatically the first one entitled to apply. But however, Jane Doe is only entitled to 50% of his estate, and Boyo and Carla will have 25% each.
Okay.
Yes.
And so again, the succession with laws of succession, we have 50% to the spouse, and the other 50% goes to any amount of children that they have.
Right. So if they have 5 children, right, 50%, that's 10%, 10%, 10%. However, Jane Doe could also decide, listen, I'm a little too old and it's too much running up and down behind attorneys. And once Boyo or Carla is over 18, she can renounce her right and she could hand over that to Carla or Boyo to apply. However, it does not mean she has given up her entitlement to her 50%. But she can just give up her right to application because she really can't be bothered with that process.
Yes, I think that squarely answers Miss Eastland Haynes' question. If the person didn't leave a will, how will the person know how to distribute assets? And we just would have described.
Yeah. Or if they have no children, then we go down the totem pole. Every week we do this question, you know, people
very concerned about this.
No spouse, no children. Then we go to the parents of the deceased. We go to grandchildren. We go to aunts and uncles. A totem pole.
Yes, understood. So I see Mr. Kanai here say, can any of the children apply before the spouse? And the answer to that is
no. It cannot be before the spouse. They can apply, but with the consent of the spouse, because the spouse is the nearest next of kin. Right. So once the spouse isn't incapacitated, not in the jurisdiction, etc., the children can apply after the spouse says, yes, go ahead. They cannot apply before the spouse. Once this is a legitimate spouse.
Right. So we have a quick question here. So if the property is the marital home where the children no longer live, is the house still shared?
It has nothing to do with who lives there. That's the first point. It's the marital home and it is property owned by both parties. If that is so, of course, it goes automatically entirely to the wife. But if it was property owned, I like the name John Doe. The property was owned only exclusively by John Doe. Then John Doe's wife and John Doe's children have a right to share. It has nothing to do with if you live there or if you don't live there.
Correct. And so we are touching on all the reasons why, again, a will is important, because those anomalies, these factors, these life changing things, i.e. the housekeeper is now like your daughter, the gardener is now your brother. You know, these things happen and they are real life, and a will helps direct that. But if you do not take such responsibility, you now have to.
Yes. And Mr. Paul, why I want to agree with you, that's a very, very good point. The caregiver becomes the daughter, the gardener becomes your son. And the other very interesting thing about that, you may have been separated from your spouse for many years because you don't believe in divorce. There are people like that. They don't believe in divorce, so they prefer to just stay separated. And during the time, the 6-7 odd years that you've been separated from your spouse, as we had said earlier, you continue to acquire assets. You bought a new car, you took out a new insurance policy for, you know, your sickness, death, whatever. Because you are still married, that spouse from whom you were separated walks right back in. And they're walking very quickly, you know, they speed right in. I'm telling you the reality right now.
Right.
And they come with marriage certificate, I am married, and they show the rings and stuff. they walk right back in. And the unfortunate thing about it, they get what they didn't earn, what they're not entitled to. You hear that all the time with children. But where she come from? Where he come from?
Yes, indeed. It is heartbreaking. It really is. And just to kind of touch back on the succession here, if in the case of John Doe had children with Jane Doe but not married to her, common law or otherwise, and the children, he has the 2 children. Anyone can apply. Is it an age? Is it a sex? Who can apply in that?
Is it an age? Is it a sex? I like that. The truth, it is none of the above. No, I shouldn't say that. It is an age. Once you reach the age of majority. Now, there was a time we had bastard and illegitimate. So you are raising an important question. Once Boyos has his father named John Doe on his birth certificate, Boyo is entitled to apply. Boyo doesn't have John Doe's name on his birth certificate. There is a preliminary process called declaration of paternity that Boyo has to go through first to establish that there's a next of kin relationship between Boyo and John Doe.